Perfectly good bankruptcy cases don't just blow up because of bad luck. They blow up because either somebody did something intentional or maybe it was just a lack of education before they filed. In this video, I'm going to go over the top 10 reasons of what takes an otherwise perfectly good bankruptcy case and makes it blow up. Stick around for number 10 because that's the one I think is the most common and the most dire. My name is Jeff Kelly. I'm a bankruptcy attorney in Northwest Georgia, and I've been practicing since 1998. My team has filed over 10,000 bankruptcy cases. Number one reason that's going to blow up a perfectly good Chapter 7 or Chapter 13 case is failure to disclose an asset. The bankruptcy code requires it. And if you don't do it, technically you are guilty of perjury. Many times people will think, well, this is just an old antique car. Nobody's going to know about it, right? Maybe the title's not recorded with the state, so people think they're going to get away with something. Don't do that. There's no bankruptcy case on planet Earth that is worth going to jail over. List all of your assets, everything. Make sure your attorney knows. Many years ago, I was filing a perfectly good bankruptcy case for this young man. And right before he left, he's like, well, maybe I should just go ahead and tell you everything. And I was like, yeah, I'm your attorney. I'm on your side. What's going on, man? And he had a 1964 fully restored Corvette that he and his dad had worked on, and he really wanted to keep it. He didn't want to risk losing it because his dad had passed away, and it was something that had a ton of sentimental value for him. I'm glad he told me because we didn't file the case. That car was worth a ton of money. So you gotta make sure that you list all your assets. Don't lie, don't fib. You think nobody's gonna find out. They will. There's it particularly bites people when they have a personal injury claim and they don't think it matters, or maybe they're worried about having to give some of those proceeds to the trustees, so they don't disclose that. Well, guess what? Under Georgia law, that PI claim, lawsuit, medical malpractice, whatever your claim is, if you don't list it as an asset in your bankruptcy case, it's automatically deemed a value of zero. Number two, another thing that can often blow up a perfectly good bankruptcy case is just flat out not telling the truth. Now, I get it. People go to their 341 hearing and they get a little bit nervous. There's nothing wrong with answering a question of, I don't know the answer. I'll get back to you. Don't create some huge problem out of nothing, a mountain out of a molehill because you're not sure of the answer. So you guess and you tell it like a fact when it's really not. Again, the penalty of perjury is number one is jail. Number two, your case will be closed without discharge. It's just not worth it. Lay it all out on the line. If you don't know the answer to the questions when you go to your court hearing, it's okay to say, I don't know. I need to get back to you on that. Number three, not reading the petition. Sometimes staff that prepare petitions make a mistake and they put something in there that shouldn't be there. That's not going to cause your case from not getting discharged. It's probably just going to call an extra amount of work, but it can cause a lot of unnecessary drama and make it feel like your case is blowing up because the debtor didn't go over everything before they signed it. Now, that never happens in my office because we spend a lot of time going over that petition with you to make sure everything is perfect so nothing blows up unnecessarily. Number four, paying loans back to friends and family right before the case gets filed. Now, the bankruptcy code governs time periods where you got to disclose that. For example, my father loaned me $5,000 to catch up on the rent. You have to disclose that in your bankruptcy petition. If you don't, technically the trustee has grounds to object to your discharge. What's normally going to happen in a case like that is listed as a preference. In a Chapter 7 situation, you're going to get your discharge, your case will move forward, and everything's gravy. But Daddy's going to get sued for the $5,000 because he got preferential treatment over other creditors. So it's very important that you answer all the questions your attorney will ask you. Make sure that petition is filled out correctly. Make sure that if you have paid back any loans recently to friends or family members, that you go over that in detail with your bankruptcy attorney. Number five, loading up charges on your credit card right before filing. So any charge you make 60 days prior to filing, it's just you're paying it back. That's in my opinion, that's per bankruptcy code. If it's 90 days before filing, it's presumed you're going to have to pay it back. Don't do that. That's a great myth that some people might hear at the water cooler from people who do not have a bar license and do not understand bankruptcy law at all. Don't run up credit cards. Don't go out and get loans right before you file bankruptcy. That is a big red flag. If you think it smells to you, imagine how bad it's going to smell to a bankruptcy trustee. Don't do it. Number six, the quitclaim deed that never got recorded. This can blow up a perfectly good case. So this is how this normally plays out. A husband and wife get divorced. The divorce judge says, husband, you're going to have to sign a quitclaim deed and give her all the equity in this house. 10 years ago, not much equity. Fast forward to today, husband now files bankruptcy. 10 years later, no quitclaim deed ever got recorded after the divorce. Ugh. Guess what? Trustee has a right to half of that house. Period. Doesn't matter that a divorce judge ordered it 10 years ago for it to be quitclaimed over. Quitclaim deed never got recorded. The day you file the case, husband is still legal owner of 50% of the property. Husband doesn't want that happening to his ex-wife. Maybe his kids still live there. Whatever, it's going to happen. That adds a whole lot of unnecessary drama to the case. So don't make sure those quitclaim deeds are recorded properly. Number seven, forgetting about an inheritance that you received. Trustees are going to want to know all the details. Have you inherited any money? How much was it? But here's the real important question. Where did the money go? Again, this adds unnecessary drama to the case. If you go over that with your bankruptcy attorney beforehand, it can all be detailed. It can all be explained. It can be documented. That would make your case go so much smoother. What would really send off alarm bells for a bankruptcy trustee is when they say, oh, you inherited $100,000 2 years ago. Where did it go? And if the debtor were to look at the trustee and say, I don't know. No. That's not going to fly. So make sure you disclose anything you have inherited recently to your bankruptcy attorney. Number eight, draining your retirement account right before bankruptcy. 401ks, IRAs are fully protected as a general rule. Don't do that. When you take it from a wonderfully protected 401k and you cash it out, number one, now you have tax debt. Number two, now you've got cash in the bank account, and the wild card exemption is $5,000 for an individual and $10,000 for a married couple. And so if you have a lot more than that, the trustee is going to say, hand it over, Red Rover. That can add a lot of unnecessary drama. Don't do that. Leave your money protected. If you have any questions like that, make sure you're going over it with your attorney before you file. The other thing that really bites people is when you take out a huge chunk of IRA or 401k, that's going to count on the means test if you received it 6 months prior to filing. That can really sneak up on you. Number nine, behaving badly at a 341 meeting of creditors. Why on earth would a debtor behave badly? For example, not answering questions, mumbling, being defiant. All of those things are going to signal to the trustee that you're hiding something. something's off, something's off kilter, something's wrong. Don't do that. Behave yourself. Be respectful. Answer the questions truthfully and honestly. Your hearing will probably take 5 minutes as a general rule. But when somebody starts acting foolishly, yelling, screaming, acting offended, that is a big red flag to the trustee that more questions need to be asked and that the hearing needs to go a lot longer to get to the bottom of what is causing this trigger. So behave yourself. Last one. Here's the biggie. Number 10, filing Chapter 7 when you probably should have filed a Chapter 13. Okay, this is important. When you file a Chapter 7, if things start going south, you don't get to just quit and say, psych, I'm out of here. I don't want to proceed. Let me give you an example of how that can be horrible for you. Let's say you file a Chapter 7 and you own a house and you say it's only worth $100,000 because that's what the tax assessor says. Never, never, never file a Chapter 7 with the tax assessor value of the house if it's possible that it's worth more. Because listen, the Chapter 7 trustee is not bound by that at all. They're going to send their realtor out to your house and they're going to value it. And if they think they can sell it and make enough money to pay your exemption and pay, a decent amount of money to the unsecured creditors, guess what's going to happen? You're going to lose your house. No way around it. No doubt about it. Don't do that. You can file a Chapter 13 if there's exposed equity. You can still wipe out a significant amount of your debt as long as you pay back whatever the unprotected equity amount is. Don't make that mistake. That's why you need to go to an experienced bankruptcy attorney who knows the ins and the outs and these kinds of rules. If you have any questions at all, if it's super general, drop it in the comments. I can try to answer it there. Otherwise, call my office. There's nothing in this video that's meant as legal advice for you. This is general information to try to help and educate you. If you want direct legal advice, call my office and we can make that happen. If you would like a free guide to Chapter 13 and Chapter 7, go to my website, kellycanhelp.com. You can download that book for free. Also, take a look at my channel. It's at Kelly Can Help on YouTube. I've got tons of videos there. I've also got lots of information on my website. We've got podcasts on kellybankruptcy.com. Educate yourself before you file. Don't let any of these 10 traps blow up your perfectly good case. Thank you for tuning in.